The world is changing faster than ever before. In the past 10 years, there has been an exponential technological evolution, the kind of technology that has revolutionized the world of work as we know it.
The Lawyers Hub was founded on the principle that law needs to interact more with technology, and that greatly affects tech policy as well as access to justice. So the Lawyers Hub exists as a conference between law and technology, working on tech policy, on emerging technologies, as well as increasing and upskilling the knowledge of lawyers in the area of technology. We support tech startups as well to ensure that the tech ecosystem also engages in policy, but as well understand issues around data protection, issues that also concern their structure, as well as intellectual property.
If you look at the evolution of technology, it's been relegated as an alternative in most systems. But the realization that the 21st century has brought us into is that technology has to be an integral part of our day-to-day systems. And if you look at some critical technology areas like artificial intelligence, blockchain, nanotechnology, biotechnology, then it gives us a strong indication that if we do not start having discussions on the use of these technology areas, as far as law is concerned, then we may be in some kind of trouble. So lawyers are leading the debate on the use of these technologies, especially in Africa.
Over the years, the Lawyers Hub has supported the innovation ecosystem, convened events such as the Africa Law Tech Festival and the Global Legal Hackathon. The Lawyers Hub has also supported government innovations within the justice sector, as well as trained government institutions and more than 10,000 lawyers across Africa on emerging tech policy.
Our dream at the Lawyers Hub is to have open access to law. We envision a continent where there is access to justice through leveraging technology and with a crowd of enlightened lawyers. We see a continent that also protects its own through better tech policies, that emerging technologies, through its regulation, will offer better value and consumer protection for the people within Kenya and within the African continent. We envision that we will convene policy makers, regulators, as well as lawyers who are more enlightened on emerging technologies and with better digital skills. And we invite you to be a part of this great vision for Kenya and for Africa.
Mbona nimehang? Yeah, good afternoon, ladies and gentlemen, and welcome to today's discussion on the Digital Health Bill that has been proposed by the Ministry of Health to Parliament for its discussion. So we are here to just have a look at how it looks like and give our own people's discussions, and then see how best we can give our memorandums and submissions to the Senate to make the bill better for us as a country. So I'm being joined by Alan. Maybe I will just give him some few minutes to introduce himself, so that he can say how he is and how excited he is for this particular discussion. Thank you.
Thank you, Ken, for having me. Thank you for Lawyers Hub for having me. My name is Alan Maleche. I work at the Kenya Legal and Ethical Issues Network on HIV and AIDS, properly known as KELIN. And we work on matters concerning health and human rights. We have been involved in the conversation around this particular bill, and we look forward to interacting with the various colleagues online to discuss the pros and cons of this bill and what we can do to make it a better bill, because it's a law that's needed to help us govern a very sensitive area of health that converges between digital technologies, data protection, safety and protection, and privacy. So looking forward to the conversation, Ken, and the rest of the colleagues online. Over.
Thank you, Alan, for the introduction. So I'll just go straight to the presentation where I'm going to just delve into the Act itself and actually take a look, a snapshot of how the Act looks like and how we got here in the first place, and look at other countries' perspective and see if it's only Kenya that actually has this particular act or bill. All other countries have actually had the first stance of this particular bill. So let me just start on by saying that in Kenya, the Digital Health Bill 2023 has emerged as a crucial side in safeguarding sensitive personal information and also ensuring the responsible handling of health data. So yet just any set of rules, it's vital for us as a people to carefully examine its contexts and in addition to the best practices. And in this particular discussion, we'll actually have a deeper look at the particular bill and examine the privacy, security, and confidentiality aspects outlined in this particular bill, and also draw comparisons from other jurisdictions and see how best they have actually established this particular context in their jurisdiction, and also have a deeper discussion on this particular bill going forward. So just delve straight into this particular the presentation, where I'm just going to give a snapshot of the bill per se. So the Digital Health Bill 2023 was received cabinet approval in Kakamega in 29th of August 2023 this year. And the bill actually seeks to establish what we call a digital health agency. It also seeks to, among other things, create and maintain a comprehensive integrated health information system. And so it actually also intends to promote innovation and the safe, efficient, and effective use of technology for healthcare. In addition, it also establishes a regulatory framework for the health ecosystem, data life cycle, among other important things like ensure privacy, confidentiality, and security of health data, and also management of health, e-waste management, and facilitates the safe and secure transfer of personal identifiable health data and client medical records to and from health facilities outside Kenya. What's in the bill, it's known as health tourism. So just taking a deeper look at what the Act says to establish this particular agency called the Digital Health Agency. Per se, if I can just give us a small explanation about the agency, it's just a body that has a board. It's like a company because it can sue on its own. It has perpetual succession. It can actually own property, as the bill suggests. And the board consists of one person who is called a Director General, who is appointed by the President. The other members will be the PS, Principal Secretary for Health, Principal Secretary for Communication and Information Ministry. There's also a Principal Secretary in the IT sector. There's also a person appointed by the county governors to this particular board of agency of this particular agency, and also the one public member is also appointed by the Cabinet Secretary for Health. So this agency shall actually develop, operationalize, and maintain the comprehensive integrated management information system. The agency shall also promote the adoption of best practices and standards. It shall also create a system for shareable and portable personal health records. It shall also ensure that the portability of health data and ensure and facilitate the collection, analysis of data for policymakers and research in the health sector, among other things, as the bill also outlines in its section 3 of that particular bill. So going to the comprehensive integrated health information system, to give you an explanation, let's say, for example, me as Dixon just walks into an hospital, then I give out my data. So this particular data is entered into a system that the bill calls electronic health record system. So this particular system contains my information. So I'm going to give my name, my date of birth, everything about my personal data. It will be entered in this particular system. So my system will be called electronic health record system. So in this particular system, it contains my information. So once they treat me, I go to the lab, I get the lab tests, they give me medication. This system will record every detail of my interaction in that particular hospital. Let's say I just walked to Kenyatta National Hospital, and everything I've done there will be recorded in this particular system, including even the medication I was given by the doctors. So this system will function as a center hub for collecting, analyzing, reporting, storing, also sharing, receiving this data that I've provided to the particular hospital. And the system will also include records related to my past interaction with the hospitals, present, future health status, and primarily the objective of this particular system I've just mentioned is to deliver a people-centric, high-quality health service, also to facilitate collection of data, reporting at all levels of healthcare. This means that if I'm going to Kenyatta National Hospital today, I'm being treated. Then next time maybe I go to, let's say, Aga Khan. Aga Khan will have my information, that's my health status that I used in Kenyatta National Hospital. So they will use that particular information to also diagnose me, because maybe there's medical records. So using the medical record, the doctors will actually use those particular records to give me a perfect diagnosis. So this is one of the objectives of this particular system, to store the data and also help in actually facilitating better medical healthcare and storage of your medical data in a very secure and sophisticated manner. And also the system is supposed to ensure that the privacy, confidentiality, and security of your data is attained, and also ensure standardization in the management of your health data. So basically, once you go to that particular hospital, you just produce your data, and the hospital will treat you, diagnosis, and everything that you do in that particular hospital. It will be recorded in this particular system. So your system, as I've just mentioned, it will be called electronic health record system. Each person has their own system, but then this system is stored in this particular hospital, and the hospital, pursuant to the Data Protection Act, is a data controller and a data processor. So our view as a lawyers hub in this particular system, I will just give a snapshot of what we saw a shortcoming from this particular system, is that if the hospital records some bad information about you, let's say maybe the mistake in saying a wrong diagnosis, when you go to a different hospital, the hospital will actually have that particular wrong information. And using that particular information, because doctors use your health status to actually diagnose you going forward, if the information first recorded is wrong, then the doctors can actually give you a wrong diagnosis in a second or third visit in a different hospital. So if you store a lot of data in one system, centralized system, there's also high risk of breach of data, because you see, maybe, for example, someone gets access to this particular information. So what will happen? Because it's stored in one particular centralized system. But the Act actually gives out a system of storage, to the anonymization of data. So it actually stipulates how best they can try to safeguard the data from an authorized access. So going to that particular access now, data governance, in the particular Act bill, you can see that the health data in the system can be classified into 5 systems. One, sensitive personal data. So that this is actually your personal information, your health status, your diagnosis. This is sensitive. The second one is administrative data, billing status, how much did you pay, those kind of information. Aggregated health data, there's also medical equipment data, and also research for health data. Because I've just said the system, information in the system actually will be used even by the government to see, let's say, for example, the system records that there are high people with malaria. So the government will say, if you feel like the people of the country, the people of Kenya are actually suffering more malaria. So they will actually go back into their tables and say, we're going to use more resources to actually try and treat this particular disease. So the system will actually also help the government in trying to see how best they can manage the health status of the people in Kenya. So there's also health data governing principles. So these principles govern the data, health data that we give in the hospitals and any healthcare facility. So the governing principles are equality and accountability, accuracy and reliability, privacy and confidentiality. Those particular principles, they actually govern how the hospital, the system, the cabinet secretary, even anyone who will have access to that particular data, how they will handle this particular data that you are giving them, that you are giving the hospital. So going also further to the cabinet secretary, who is now the CS, for now it's Nakumisha. So the CS, in consultation with the Director General, as I said, the Director General is the chairman of the agency, shall establish a health data governing framework. So this framework shall provide guidelines to promote the effective use of legacy data, establish standards for integration and exchange of health data, ensure regular update and availability of national health data, establish a standard for and conduct routine data quality checks in the system. Also, we can actually see that the system, the framework will actually provide guidance in the integration and interoperability of health information system into the system per set standards, because the bill actually sets the standards and also the principles that I've just mentioned should actually be followed. Going further into the confidentiality, privacy, and the sensitivity of the security of the data. So here, we're actually looking at the confidential aspects, the privacy aspect, and the security of your data, healthcare data. So the sensitive personal data within the system that I've just mentioned will not be disclosed. So if once the data that you are provided in the system, it will not be disclosed to third parties unless, one, you are unable to provide that particular consent. Because for you to provide data, for your data to be given out, you must provide what we call consent. But then you may find that you are in that particular critical condition that you cannot actually provide consent. So in this particular time, the health facility will be given a written authorization for disclosure of this particular data by a person authorized by the data subject. So let's just, for example, I am in the hospital and then I was taken there by my friend or my mom. So in this particular state, my mom, because I will not be able to give my consent, will actually be able to give a written authorization for my data to be provided, because I'm in that particular state where I cannot give consent. Secondly, your data can be disclosed to someone else if a particular law provides, maybe the Data Protection Act. There's also a court order so that the hospital to disclose this particular data. Also, the health services are provided without the need for informed consent. So where this need, where this providence of services, where you don't actually need consent from the subject. Among other things that actually the Act says, this of failing to treat the data subjects or a group of individuals that include data subjects will pose a significant risk to public health, because you see, for the doctor, your health is more paramount to them. So if it's in a particular state where they cannot treat you without this particular information, then they have to access the data for them to use it to treat you, because your health is paramount to them according to the code of standards they have. So the data that is held in the system shall be maintained for a minimum of 12 years. And actually this particular years can be extended by you, or it can be extended by the law, also it can be extended by historical statistics or research purposes. The data held also shall be secured, like I've just mentioned, in the identification manner, anonymization, pseudonymization, archiving, and other manners, but actually this particular manner should actually ensure that data is confidential, private, and also secure from unauthorized access. So the cabinet secretary shall also be responsible for the confidentiality, privacy, and security of your data in the data bank. Also, the CS will actually ensure that the privacy of the data held in the system, in the whole system, that cycle from Aga Khan, Kenyatta, and any information that you have provided that is in the system, it's the work of the CS to ensure your data is secure, confidential, and also private. Among other things that the Act actually stipulates for the CS is actually ensure that the CS establishes seamless integration and interoperability of national health data bank with other relevant databases. The CS also has a work of establishing the security measures in the system to protect sensitive personal data, including personalization, role-based user rights, issues to do with audits, digital and physical security of the system. But basically, the CS has the power and the ultimate guidance to ensure your data in the system is protected, confidential, private, and also secure from unauthorized access. That is the work of the Cabinet Secretary for Health, according to the particular bill. So moving further, there's also what we call the County Executive Committee member, who is in charge of the health in the particular county. So the committee member shall also ensure that there's an established county health data bank, because you see the data bank actually has the counties are the ones that are responsible for health status. So the county executive committee will ensure the health is established a county health bank. The data is stored in a confidential manner in the health bank, and also establishes seamless integration of the county data bank with other relevant databases and data banks. Also, the health data stored in a health bank is utilized for the following purposes, because now a health bank is just a place where they store this particular data. It's called a health bank, where you have all the information stored in that particular bank. So this particular bank, the health data stored in this bank is utilized for the following purposes. So number one is to identify individuals. Number two, identify health service providers. Number three, also to ensure that assessing and addressing public health needs. I've just mentioned the government will use this particular data to ensure all those activities. So actually almost going to finish my presentation. The data controller shall ensure data is transmitted in the right way, and ensure that the agents in that particular working with the data controller do have access, but then they do not disclose this particular access, retain or dispose of sensitive personal data. Moving forward, the data controller must safeguard sensitive personal data, implement reasonable administrative, technical, and physical measures to ensure privacy, confidentiality, and security of your data. You can also, moving forward, actually a health bank, just mentioned the health bank, may decline to provide access to all or part of sensitive health data on the grounds that, one, access is restricted by a court process, another law prohibits, let's say the Data Protection Act, information was collected or created during an ongoing inspection, and all sorts of things that the Act actually provides. So lastly, I've just mentioned there's also what we call health tourism, where information, your informational data is being transferred from this particular country to another jurisdiction. The Act actually provides a system on how this particular information is transferred from one system jurisdiction to another, and to ensure your identity is not actually disclosed that easily. It's secure, information is secure, privacy is outlined, and everything is actually in place. So basically, in conclusion, this particular bill is supposed to ensure that your data you provide in the hospital is confidentially stored, is securely stored, and also it's actually private from unauthorized access. So as we delve into this particular discussion going further, we want to see how best we can make this particular bill work for us as a country, and also provide security to our data to provide in our particular health facilities. So in this particular point, I'll invite Rispa Onyango, who is the policy lead in the Lawyers Hub, to also take lead in the panel discussion. Thank you.
Thank you so much, Dixon, for that comprehensive breakdown on the bill. I think it's really set us up for success in just trying to unpack some of the issues coming in. And so what I want us to do is to just get into a quick Q&A with our panelist for the day. And that is the Executive Director at Kelin, Alan Maleche. He is a practicing lawyer. He has been and continues to be a human rights activist with over 10 years experience working in the field of law, ethics, health, and human rights related issues. So karibu sana, Alan. I hope your audio is good. Awesome. So I think to take us through this conversation and just based off what Dixon has highlighted, I think my first question is, what are your thoughts, your initial thoughts on the provisions of the Digital Health Bill? What do you think of it? What comes to mind?
So I think what comes to mind is a law that's long overdue. We have been working in the health sector for a very long time without very clear direction around laws and policies of how data is collected, data is stored, data is processed, and data is shared. We largely celebrated the passing of the Data Protection Act, but it was not very detailed around the issues of health data. And so the drafting of this particular bill is a very welcome step in the health sector, but generally for all Kenyans, because we generally give data, but we are not comfortable in terms of who holds our data. Sometimes we don't know who has access to it. And so for me, I feel this law is timely, and this law would be a good law that will help put some sanity in the health sector around how data is collected, stored, and shared among different players. So definitely a welcomed law, but we have to do a bit more to strengthen it and make it more relevant for Kenyans and others who interact with the healthcare system.
Yeah. So thanks for that. And I think what I probably want to do is just highlight a few aspects of this particular law. Of course, we can't cover it in its, entirety, but we could single out a few nuances here and there. And probably ask you to address those. Now, looking at health data, there are different aspects to it, and there are different steps to it, right? So we have what is considered the primary use of data, which is obviously healthcare provision, but then we also have other ways in which we interact with health data. So there is research, there's public health, and I've also seen that there's a lot of either social care or health management, just in terms of record keeping and making sure they're up to par in that particular sense. So because of those different aspects of data, and also because of how they are differently intersecting, I wanted to first talk about the use of tech in the management of, in the provision of either healthcare or, in the management of public records or public health, etc. We now have so many tools, that are helping actualize digital health. So we have within the strict hospital care sense, but then we also have just in the general day-to-day activities. Now we have wearables, we have people having sensors, people have applications that can easily be able to either get their heartbeat, get all this information about them. So my question is, to what extent do you think this law actually takes care of that aspect, takes care of the strictly non-medical context, vis-a-vis maybe other laws that you have interacted with, or just based off your experience?
Thank you, Rispa. That's not a very easy question, but I'll try to attempt it. I think the first thing the law does that's extremely good is that the law spells out what health data is. And for those of us who've had a chance to look at the law, or will have a chance to look at it, it basically tries to expand the meaning of the term health data, and includes both physical or mental health and records regarding past, present, future state of data. And then it's aimed to be that it is information that is collected in the course of registration or for the provision of health services, or data which associates the data subjects, the provision of specific health services. So from that definition, you could roughly say that they are contemplating data that is collected for purposes of providing healthcare services, which basically means if you choose to put on a smartwatch and you decide to do 100 steps, or you decide to get your blood pressure measured, that is not data that is contemplated under this particular act, because it's not data that is aimed at providing a healthcare service to you. So it's one to you in terms of who's the maker of the smartphone, the data they collect, where do they take it, and who's then able to regulate that. Maybe that could be regulated by a broader data protection law, but specifically what this law then envisions is that the data that is being collected is data that is aimed at ensuring that you're getting a particular healthcare service. And so anything that falls in the realm of what the law would see as provision of healthcare services and the information is collected, then this particular law would apply. So the question would then become, given that it's a digital health data law or bill, should it go beyond that, or should it stay just within the confines of health? My submission would be that it would stay in the confines of health, because we are more concerned around health information that is collected for purposes of trying to ensure people access their right to health. And it is true that there is increased use of various artificial intelligence tools, digital technologies that help monitor our pressure, our steps, our physical activity. But again, not all that is done within a context of providing healthcare. It's more of just people being self-conscious about their own physical and mental state of things. So I think for me, that's a clear distinction of this law, that it's not dealing with general data protection, it's dealing with that data that's collected within the healthcare system, though they emphasize on digital tools, but I would argue that it also applies to previous data that has been collected, and hopefully when it comes into play and it's made operational, if it's passed by Parliament and they go through the whole legislative process, then it will equally apply to records and information that have been held in the past that is not even digital information. Back to you, Rispa.
Awesome. Thank you so much, Alan, for that clarification, and also just unpacking the scope of that. And I think maybe to follow into my next question, which is, some of the key provisions you're finding as really well elaborated within this particular bill, and the aspects which you think are actually still missing and would be important to have within this particular law if passed.
Thanks again, Rispa, for that. I think some of the sections that stand out for me is particularly the sections or the part of the act that deals with confidentiality, privacy, and security of data. Because based on our experience of working in the health sector, those are the main things that worry people about data that has been collected. How is it kept confidential, especially when you're dealing with data of certain populations that are either stigmatized or in certain cases criminalized, or if their data leaks, they are likely to be subjected to a lot of stigma and discrimination. This includes people like persons who are living with HIV or persons who have any condition that are considered to be stigmatized. So that is a good section, and it ranges from section 26 to section 40 of the Act, where it tries to emphasize the importance of confidentiality, the importance of privacy, and the importance of security of the data. I think for me, those are the sections that stand out for me. And then also the sections that speak to e-health service delivery. It then speaks to now when you bring in AI and digital tools into delivery of healthcare services, what then is governing it, what then is guiding it, and what is then being able to take it forward. So I think for me, those are the two positive steps that are quite critical. But additionally, also the definitions are quite comprehensive in terms of health data, who is a health data operator. So I think they've done a fairly good job around definitions. I think areas that would benefit and be strengthened on, the first one for me is around the fact that there's not a well-defined term around what sensitive data is. And given that when you're dealing with people's health data, I think we need to have some level of classification. What would be sensitive? Is it a person's HIV status? Is it their blood pressure? Is it their heartbeat rate? Or what is it that is sensitive? What is not sensitive? I don't seem to see a clear definition of what that sensitive data means. Then I think there's also a bit of work that could be done to improve the provisions around informed consent, defining what it is. And as Ken earlier talked about, defining what are the different circumstances in which consent may be waived or consent may be done by someone else if the principal or primary person is not in a position to be able to take the issue, is unable to give informed consent in a situation where his data needs to be collected. The last and emerging thing that is affecting all of us as Kenyans is around this issue of health tourism. And I worry about the fact that how the bill can be able to ensure that sharing of data, particularly for health tourism, say you go to a different country or you go to a different place where you want your data to be shared for them to be able to give you access to quality treatment or to be able to deal with a certain situation. How will that be strengthened? The current clauses around sections 47 and 48 are fairly broad. I would understand it's a law and it may need regulations, but there's some strengthening and improving of that because there's a lot of health tourism going on, especially between Kenya and India and the number of people who seek out healthcare services. I think we may benefit as we review the law, as the law goes into public participation, as our legislators will debate about it. I think they should take into account ways in which they can strengthen those aspects of the law. But generally, it's a good start, and I would encourage many people to keenly look at the law and see from a healthcare worker's perspective, from a user's perspective, from a regulator's perspective, what is it that I can do to make this law better for the health sector to be able to operate efficiently and to ensure that our data is safeguarded. Back to you, Rispa.
Thank you, Alan. I think maybe you could correct me if I'm wrong, but I did not particularly interact with how the bill is dealing with breaches or notification of breach and how that is supposed to be handled. And my inference was probably that would then lean on the Data Protection Act as we know it. But I think I would really like to get your sentiments of that on that, just because of how the nature of course, data, right? And also some of the cases we have seen arising even just within our context. And I would like to marry that with the question around infrastructure. We find that a lot of conversation currently has been leaning towards data centers or leaning towards these particular systems, for example, as is being set up within this particular bill. There is the call for having both the national data center and having it as well as at the county level. What, just within your work experience, has been your interaction with our infrastructure, particularly within the healthcare space, and whether we actually need to, build on that fast, or it's actually things that are in place, and so it's just an enforcement issue?
Thanks, Rispa. I think actually the law at sections 40 and I think 41 speak to the whole issue of breaches of data. And if I recall fairly well, they provide for the Cabinet Secretary to develop regulations for the disposal of sensitive and personal data. So they talk about situations around in what way could medical data or data for research or health data could be breached, and they talk about when a person tampers with the data, when a person has privilege and releases that data without consent, when a person loses the data or steals the data. And so what the law then basically says is that it just makes it an offense, and it says a person can be liable on conviction to a fine and not, I think, exceeding 500,000 shillings. And then it also marries to the fact that the provisions of the Data Protection Act will then be able to apply in terms of the relevant penalties. So on the question around breaches, and generally for this act, there's a lot of marrying that needs to happen between the provisions of the Data Protection Act, which are general around all data and speaks to some health data, with this particular law that now is specific for the health sector. So this is part of why there's been public consultation, or there's going to be public consultation and sort of alignment of this act to see how well does it cross-reference to the Data Protection Act, and where the Data Protection Act is not adequate on health issues, how well can this particular act be able to be strengthened so that it is more comprehensive, and it then provides for where there are gaps in the Data Protection Act that is not covering for health issue. So there's some cross relationship that needs to happen there, and some alignment of the law to be able to ensure that breaches of data are taken care of, because they are quite a serious issue, as I said, especially for people who have stigmatized diseases, people who are stigmatized populations, such as persons with albinism or persons with mental illness. Certain data requires a higher level of protection. In terms of infrastructure, I think that's where our challenge will be. We may draft a very good law, we may draft a very well thought out law, but if there's no budget, if there's no investment in terms of training all those people who are going to be employed or set up in the different agencies, investing in development of the regulation, sensitization of the Kenyan citizens, sensitization of the health service provider, that's the kind of the infrastructure that is missing. And from our work in this sector scaling, what we see so far is both national and county governments relying a lot on development partners, relying a lot on the private sector colleagues who are coming up with different technologies to be able to support components of this work. Whereas that is good and development partners or philanthropies may be useful, it is not sustainable, because at the end of the day, the government must make the investment, the government must own it, because the healthcare workers are employed by them, either the national government, either the county government. And so the ability to be trained, the ability to know how to use the digital technologies, the ability to know how to store the data, how to keep it safely is extremely important, but also the ability of having good internet connection, having good connectivity are all critical. Otherwise, we will see the challenges we've been seeing around people trying to pay for park fees, the system is down and nothing can happen. That could be very disastrous in the case of people seeking healthcare services, and maybe it's an emergency and they cannot wait. So the infrastructure investment is not just about the equipment, it's also about the people who need to run the system. How well are they trained? How well are they supported? How do they go for regular uptake for more and new information, because technology is evolving. So a bit of investment will have to be made, and I'm hoping that, given that the government is really pushing to have this law in place in light of their seriousness towards making universal healthcare coverage work, then maybe it'll equally come with more investments in terms of human resource finances to be able to make these particular provisions operational.
You have talked about development partners and private sector involvement, and that has actually prompted my next question, which I mentioned to you earlier when we were talking about what is now being termed as Googleization of health research. And now this brings in, other than just the primary use of health data, right, that the associated uses that we have, and in this case, looking at research. So one scenario that I did find was a health organization or trust that worked in collaboration with Google to be able to, I think, conduct some sort of research within the health space. And the UK regulator actually found that that sharing of data within that confines, because they ended up sharing up to 1.6 million patients' data information, personal data information with Google to be able to kind of push that research, but it was found to be illegal. One, because of the transparency, those lack of transparency, particularly on how Google was processing this information and what it was trying to use this health data for. And then also they were unable to establish the legal grounds that was being used by Google to be able to continue with whatever research that was happening in this sense. So I think my question is, what are you seeing as the approach in trying to merge these two areas? Because on the one end we have this law looking at health data as a national asset, if I could put it that way. And then on the other end, we have, the incorporation of different players, so the private sector, the big tech, and them participating again also in this process. So what would be your comments on that?
I think it's not an easy matter, and it's not only a specific Kenyan problem. It's more of a problem of certain private sector organizations are exploiting regions where the legal framework and the policy framework is not strong enough to control how data is collected, who the data is shared with, and if there's anything that comes out from the benefit of sharing that data, how is that benefit taken into account? I think the recent example that comes to mind is the WorldCoin conversation, where we had people having their irises being scanned, and by the time the people were giving consent, which is again a point I emphasize about this law being more specific around consent, because at the time you're agreeing to have your iris scanned, at the time you're agreeing to have your biometrics or your fingerprints to be taken, you definitely should know, if it's a case of research, who's collecting it, who is storing it, and if they're going to share it with another person, how do they get in touch with you to let you know that they're going to share for you to be able to give your consent? We've had a number of cases in the US under their health insurance portability, and I can't remember the full name, but it was the HIPAA Act. There's been concerns where people have gone to their normal clinicians who are doing research for, say, sickle cell anemia or blood cancer, and some of the data they have collected, they have shared with research organizations who have either come up with a medicine, and then there's not been sharing of benefits, and there's been litigation around it. So it's quite a complex issue, but I feel it's the duty of the government to control private actors as they get into the realm of engaging in healthcare research, provision of healthcare services, and in any realm where they collect data and they share it, especially for profitability purposes. At the end of the day, the person whose data was collected needs to be in a position to know that the data is either being shared or the data is either going to be used for something else, and they need to have a say whether they know it or not. And that's why we then emphasize around the need of some legal literacy being done to encourage as many people to understand what does this mean for them, what does the obligation extend to them. And there are some private sector companies that do want to follow due process and the law, but there are many who will look through the legal loopholes and easily try to see how well they are able to collect as much data as possible to help inform their marketing strategies, to help them know which target audience to reach in terms of their product. And that's why we need to safeguard the Kenyan citizens and those who are within Kenya accessing healthcare services, to be able to ensure that their data is not collected without their consent and it's shared with their knowledge and with their permission going forward. So I'm hopeful that if this law is passed and this law is fully made operational through providing the necessary resources to not only the Ministry of Health, but the Data Protection Commission, the ICT Department, the Office of the Attorney General, the Judiciary, the Office of the Director of Public Prosecutions, all these arms need to work together in a multi-sectoral way that will ensure that we are getting the right effect of this particular law.
Okay, I see on the chat there's actually someone who I think has a similar question, and probably you can tell me whether you think you have any additional comments on the same. So Esther was asking, how will this bill impact international organizations that fund healthcare and require patient data to be submitted to them as part of reporting?
So thank you for the question, Esther. The impact of this bill on not only international organizations, but even local organizations is something that is akin to what the Data Protection Office did around having people to be trained around if you're handling sensitive data, if you're handling certain categories of data, what is the sensitization you need and what do you have to go through to be able to know you're compliant with what the law requires. And so what is then going to happen should this bill go and be passed by Parliament or both houses of the National Assembly and the Senate and eventually put into operation? It will require that those who are collecting data from patients or those they are providing health services to be able to ensure they are put in a bank with certain rules and regulations of how they are shared. So rules and guidelines will have to be developed to guide them on how to share that data. They can't just pick it and share it should the law come into place. So again, calls for regulations, calls for practice and policies, but the law would be able to give that particular guide. Over.
Yeah, thank you, Alan. And I think the bill touches a lot on having the CS putting either in place some guidelines, putting standards, putting regulations. So I think it kind of gives leeway to elaborate a bit further on some of those issues. And hopefully now, you know, in terms of just implementation and making sure that is quickly done, I think that would be the kind of follow-up to it. And so, yeah, I think as we are coming to the end of this, and as I will just be seeking your final comments, I think I'm looking at additional questions. We have the bill seems to give more powers to the CS Health, especially in regards to the security and privacy of the data collected. Are you seeing any oversight mechanisms to the CS?
Should I answer that, Rispa?
Yeah, yes, please, Alan.
Okay, so I'm also quickly looking at the chart so that we don't leave out anyone who has sections, but I think this, yes, primarily this bill would sit under the Ministry of Health, under the CS of Health. The oversight for the CS of Health would be definitely, the judiciary remains one oversight. The Data Protection Commission is another oversight. And eventually there's an agency that is being created under this particular act, which should also serve as an oversight. So there are various angles towards oversight, but the key question is around, do the authorities that have to play an oversight role, even including the National Human Rights Commission or even the Gender Commission, because there may be data of certain groups who are vulnerable that is mishandled or is not treated in a right way, they may have jurisdiction in that sense. The question becomes, are they aware about it? How do they understand it and how they're able to take it forward? And then in terms of William Obirio's question, there's a section, I think it's section 59, that talks about general fines and imprisonment if someone breaches some of those things or the things that have been set out. So there's an angle around it that is being taken into account in terms of ensuring there. But definitely the oversight of not only the CS, but the health agency that is being set up to deal with this data, the actual officers, because it's creating many offices, many roles. There's definitely oversight mechanisms, but for oversight mechanisms to work, there needs to be a way to break down this law in a way citizens would be able to understand it in the easiest way possible, so that they know when something wrong has happened, where can they go to, who can they go to, and who can assist them to be able to take this forward. So that's an important question and an important thing that happened. And then Rispa, one important thing that you said, and as I conclude so that I could turn it over to you, is the ability to get the regulations in place and the ability to be able to ensure those who need to enforce the regulations are well trained and are taking it forward will be what will be critical. We have seen a lot of paralysis in this country. Once a law has been passed, you tick the box, and when you do a legal environmental assessment, the law is there. But the question of making it operational is where the rubber hits the road. And I think my clarion call to anyone who's interested in this law, and that should be every Kenyan, because we all have our health data collected, is how best do you involve yourself in the public participation? How best do you follow up with your member of parliament or your senator to ensure the right provisions are put into the law? And eventually when the law becomes, when the bill comes to be passed as law, how well do we ensure that we have the right regulations and it's being enforced as we're able to move forward? So I'll leave it at that, but turn it over to you. Over.
Thank you. Thank you so much, Alan. I think to allow my colleague Crispin to lend his voice to something you had already begun to allude to, which is commercialization of data vis-a-vis having data as a national asset. Crispin, if you're able to hear us and probably give comments on that or pose some additional question to Alan in that sense, so that we can begin to wrap up.
Thank you, Rispa. And yes, I can hear you clearly. Now, we have to also mention that the Health Act 2017 is the basis for this kind of conversation. And there are obviously human rights implications to this law. And one of the things that we'll start to look at is how access to health on digital technologies and emerging technologies will present issues of access, will also present issues to do with consumer protection, because then you start to look at the quality of services then offered on those digital platforms. But specifically then, we start to see the interplay between the Data Protection Act and this particular law, because the instance you start processing data, say for commercial purposes, say for cross-border transfers, you start to see that elements of consent which should be expressed start to kick in. Therefore, the regulations will then have to be very, very specific in that regard. Apart from those elements that I have raised, there are issues to do with previous initiatives such as the Kenya Health Data Collaborative, which was launched in the year 2017, 2016-2017, and you start to see the interaction. How do we handle issues of data transfers, data sharing for purposes of health provision on digital technologies then? Those were my short reflections, and as we enter into public participation, I'd really look forward to see what kind of submissions we're able to make and what Kenyans are able to say about this particular bill, considering that we already have elements in the general data protection regulations and the enforcement regulations to deal with fines. And we'll start to ask also if the 500,000 fine is really sufficient when dealing with sensitive personal data. Thank you, Rispa.
Yeah, I feel like that question around the fine has been, recurrent, and especially now that we are talking about sensitive health data. Like, is there anything we can do to kind of upgrade that fine? But I think, yeah, thank you so much for your sentiments, Crispin. I'm seeing on the chat, a number of people are saying this was a very insightful discussion, and they've learned quite a bit from it. So thank you guys for joining us as well on the YouTube stream. So to you, Alan, do you have any final remarks as relates to this particular bill, and any expectations that you have even as we're getting into the public participation era for this particular law?
Thank you, Rispa, for getting back to me. I just want to agree with Bosire's sentiments, and yeah, it's important that we take into account that this act is going to have to cross-reference many other acts, including the Primary Health Law Act of 2017 that set up a section around e-health and guided the minister or the cabinet secretary at that time to put into place laws and regulations. But it's a very sensitive issue. As they say, data is the new gold, and it's more of gold when it comes to health data, because we have seen what this data can do if it lands in the right hands and if it lands in the wrong hands. And so for me, Rispa, my plea, as Crispin has said, is for Kenyans to look onto this law, submit memorandums, follow through with their members of parliament around what kind of law they have, and if they're satisfied with the provisions that come out of the August House and to the President to assent to it, then we move forward with its implementation. If there are still areas that need to be addressed, then we have to look at what review mechanisms exist. But it's important at least we have a legal framework in place, because this is a ticking time bomb where if we don't have a clear framework that tells us how our data is held and stored, we are likely to get ourselves in more WorldCoin situations, and many, many others that we are yet to unearth have been reported. So thank you for having me, and looking forward to more interaction on this subject matter. I've enjoyed the conversation with you, my fellow panelists, and all the people who have commented online. I appreciate your comments. Thank you.
Thank you so much, Alan, and thank you for your time. We have learned quite a bit from you, and we are also looking forward to putting in some of those submissions, and we invite you guys to join us in putting our voice out there and making sure we actually have something that works for all of us. So again, thank you so much, Alan, for joining us. Thank you, Bosire, Dixon, and even the team here at the Lawyers Hub for putting this together. And for everyone who's been able to join us online on YouTube via Zoom, we are very grateful, and we hope that we can continue engaging. Should you want to join our submissions, we invite you to do so and share that with us. You can do that through policy@lawyershubafrica.com. You can share that with us, and then we'll be able to, add that to our document and hopefully have a comprehensive document that we share with the National Parliament. And I think with that, we can wrap it up here. And we look forward to further engagement, particularly with Kellen, who have been very supportive in this, and with the rest of the stakeholders who are interested in matters health, matters digital health. So with that, enjoy the rest of your day, have a good lunch hour, and see you next time.
Great, bye.
All right, bye, thank you.